चपाती द्या.
Good afternoon, everyone. It is a great pleasure to welcome you all to the third KSLW National Moot Court Workshop, where we will focus on the crucial skills of courtroom etiquette and argumentation, two essential pillars of effective legal practice. While legal knowledge and
Recording
research
in progress.
it is how we present the knowledge, interact in the courtroom, and structure our arguments that sets the stage for success in any legal setting. Today, we have the unique opportunity to hone these skills and better understand the art of persuasion and professional conduct that it is so vital to the legal profession. We are privileged to have with us Mr. Shashank Kumar, an expert whose knowledge and experience will greatly enrich our understanding of courtroom practices. Sir is an assistant professor and PhD candidate in competition law at Alliance University, Bengaluru. His academic interests includes corporate law, investment law, corporate finance, mercantile law, and mergers and acquisitions. With over 8 years of experience in legal academia, he had made significant contribution to curriculum development, including his work on contemporary law curricula and the introduction of new subjects at both Christ University and Alliance University. Sir holds an LLM in banking and finance law from NLU Jodhpur, and he's also a graduate of Bharati Vidyapeeth University, where he has completed his BBA LLB with a specialization in business law. Additionally, he has a postgraduate diploma in alternative dispute resolution. His vast experience includes participation in moot courts, conferences, and legal dialogues, which has provided him with a wealth of practical insight into the evolving landscape of law and a legal advocacy. Without further delay, I invite Sir Shashank Kumar to share his invaluable insight with us. Sir, the floor is yours.
Right. Thank you so much for such a warm introduction. Okay, and thank you for Canaria School of Law for inviting me to speak on this topic. And this is something which has been very close to my heart as well. Uh, because I believe judging multiple, as a student, I participated in a lot of moot court competitions around the country, participated in some, won some. As a professional, I have been able to uh, work as a judge in multiple national law moot court competitions, and there are certain things that I believe that should be some few things that the students probably are not as well trained in. And the reason why students sometimes feel that they're not as much trained in these skills is because there is a vast difference between the real practice as it is and what we call moot court. Moot court probably is a step ahead or a step superior to real court practices in few terms. Right, I'm not saying that doing a moot court is better than real court experience, not from far, but the expectations in certain regards is much higher. And the first of that is the first thing that I want to discuss with everyone, that is courtroom etiquettes. Now, there are a lot of things that uh, in a real court of law, a lawyer can get away with, right? In moot courts, the stakes in these things are a bit higher. So, the expectations from you is a bit higher. And in terms of that, there are two types of communications that happens in a court of law, both of which needs to follow very strict line of discipline. We understand that, see, legal profession is a very conservative profession by nature. We follow traditions which have been established hundreds of years back, right from the uniform to salutations to way you agree or disagree with the court, all of that has been practiced for hundreds of years in the same fashion. And in that sense, even today, the judges, the lawyers are very strict about that. And in terms of that, in moot courts, when we are training the students to be able to participate in moot courts, the level of scrutiny is still higher than the normal courts. The reason is because we are trying to train people for the perfect scenario. So even if they folly to some extent, even if they miss out on some etiquettes, it's not as problematic for them. The problem is in a real life scenario, if you miss out on few of these etiquettes, that somehow there have been many instances where smallest of the mistakes have had very serious reactions from the bench. Just to give you an example, very recently, um, I was looking at the live proceedings of the Supreme Court about a couple of weeks ago, where one uh, lawyer in the court of the Chief Justice of India, then Mr. D.Y. Chandrachud, so he was addressing the bench, and while addressing the bench, agreeing with the bench, he used the word "yeah." And there's a very common word, is it not? We talk to people, and instead of yes or any other word that we agree with, use for showing our consent or agreement, we use the word yeah. And he did the same thing. The Honorable Chief Justice had a very strong reaction to that. And he said that I do not particularly like the use of the word yeah in my courtroom. And that shows how much the judicial system, the legal system cares about these etiquettes. And therefore, it is the duty of institutions to train people in these etiquettes at the highest level. Now, there can be occasions where certain lawyers are arguing in certain courts where the same language, use of the word yeah or any such word is accepted to some extent. But that does not uh, mean that the same will be is part of the accepted etiquettes, as we call it. Now, so I want this to be a very practical way in which I want to train the students, right? And in that context, uh, I want to know from the moderator, do the students have the right to unmute themselves if they want?
Yes, sir. If you want an interactive session, you can.
I want a very extremely interactive session. So,
Yes, sir. We can interact. We can.
okay, perfect. Okay, so let me divide uh, the first part of my presentation in two parts. The first part, that is your decorum and etiquette, right? And then in the next part, I'm going to talk about argumentation and how you create arguments out of law. First part, when we talk about etiquettes, again, there are two types of etiquettes that we observe in a moot court. One is the verbal part of it, one is non-verbal part of it, which is your body language. When we talk about verbal part of etiquettes, right, it includes how you address the bench, right, how you communicate. But before we go into that, let me start with non-verbal part. That will be better. So again, I would remember the first advice which was given by my senior in my very first internship, and that is something that I followed in moot courts all along, and there's something which is extremely accepted. That is, when you are entering a courtroom, when you are entering a courtroom, the first thing that you do is, can somebody tell me what is the first thing that you do? Yes, surely. Very right. You bow to the bench. You take a bow. And when you take a bow, it should not look like a half-hearted bow where you're turning your neck like this, right? It should be a full bow, right? Tilting right from your stomach, right? You take a complete 90-degree bow to the court when you're entering. And if in case you are sitting there, you're standing there in a courtroom, and the judge enters, right? Then that is the moment when the judge has approached his chair, when he's standing in front of his chair, before he takes the seat. That is when you offer that bow. That is the first step. And whatever I'm telling you right now, in most of the moot courts that I have been to, I have organized, or I have just, there are serious marks deductions for these small mannerisms, right? So that is where you take a bow, and then you do not take a seat before the judge takes a seat, or if you have instructions to take a seat from the bench. So that is step one, right? You take a bow. The judge sits, he tells you to sit, and then you take a seat, right? Now, in a moot court, generally the setup is, if the judge is sitting here, on the right hand side of the judge is the petitioner, plaintiff, uh, the complainant, informant, so the party who has filed the case, in that case. And the left hand side is generally the respondent or the defendant, as the case may be, right? Then when you take a seat, the first thing which happens is the court master will generally ask you about your division of time. Moot courts are time bound exercises, and therefore you have limited time in which you have to present your arguments. And how do you do that? I'll come to that in the next part of my presentation. So the first thing is they ask you for the division of time. It's very important that you know how you are going to divide time among speakers, and we'll discuss how you do that. But for now, understand, you take the division, right? And then the motion starts, right? Where the first speaker of the petitioner asks permission. Understand again, There's something which you'll not see in real courts. These are few things that you'll not see in real courts, real courtroom practice. You'll not see a judge, lawyer standing up and asking to approach the dais, right? The case is called out, the lawyer goes down there, right? Now, in this case, you will stand up and you will ask permission to approach the dais, right? When you're standing in front of a dais, again, there are a few things. Again, I'm talking about the courtroom etiquettes, few things that you must take care of. And these are things that I believe the students may not be as much aware that how much important this becomes. When you are arguing a case, you don't read a memorial. Memorial is there. When you are asked to argue, there's something else a judge wants to see in you. He wants to see whether you have the competence to deliver an argument. To read an argument and to deliver an argument is different. So when you deliver an argument, you are not just using your voice, though you're using your voice to a better effect, but you're using your entire body, right, to deliver an argument. In that case, what's important is you know how to stand, how to speak, and uh, what your hands do at that time. So generally, if there's a podium, right, or if there's no podium, it's fine as well. If there's a podium, you always stand about half a feet away from the podium. You do not lean onto the podium. You do not have your hands on the podium, right? You're not taking, what do you say, support of the podium to stand. That is considered very rude, right? When you're standing in the podium with your hands on the podium, leaning on the podium, it's not considered good manners. And the other thing which it does, it when you have your hands on the podium, that means you cannot use your hand to uh, deliver the argument that you want to deliver. So in that context, you always step away and keep your hands free. And then your hand helps you to deliver a particular argument. And when you're using your hand, you have to again take care of a couple of things. First thing is there's a orbit around your hands, which is free zone for your hands to move. You cannot move beyond that. Generally, a few inches from your shoulders is fine. So if I may just use my computer screen. Okay. So if I use my hand to this extent, I don't know if it is looking weird on the screen right now. So I'm using my hands just around few centimeters away from my shoulders. That's fine. I can use this hand to make gestures, to make arguments. I cannot use it beyond this. So if I'm using this, then again, it is something which is not appreciated, right? So you cannot take too much space. You do have to take some space to show confidence in your argument. You cannot take too much space, right? That is again. When you're standing, you always stand with your feet firm on the ground and you do not walk. You do not take a step towards the podium, back from the podium. You stand with your feet firmly on the ground, right? That's another thing. Now, if you have to communicate with the bench, right? If you have to deliver some document to the bench, if you want the bench to read any of your submissions, or if you have a compendium that you want to show the judge, if you have a judgment that you want to show the judge, you never go to the podium and give judge this any article, any case, any book that you want to show them. Generally, any transactions in that sort which happens to the with the bench must happen with the through the court master. So you will give that to the court master, and then the court master delivers it to the judge. Another thing which is very important in terms of moot court, in terms of moot court etiquettes, is when one speaker is making his submissions, what other two people, the researcher and the other speaker, is doing uh, on the what is the side of the podium. They generally, it is best if they do not interfere at all. If there is no involvement of the other two people when one person is making a submission. If in any case a question is being asked and the other speaker or the researcher has the answer and the speaker is not able to recollect, remember you do not have to become restless. So generally what I see that a question is asked, right, and the researcher is too excited about an answer and then he jumps to the podium, right? He jumps to the podium that, see this. Any sudden movements of that sort which startles the bench is not appreciated. So it is very important generally, and then trying to fetch the attention of the speaker towards you again is something that you shouldn't do. So generally, what is the easiest way to do that? That you have generally use a stick-on notes and just stick it on the paper that he is reading from. Right? He'll see on his own time. You do not want to break the flow of the speaker as well. That is not just rude, it is not just inappropriate. It also breaks the rhythm of the speaker. Sometimes he may forget a particular point that he's trying to make. So that is another set of what do you say, important instruction, right? Now, whenever you want to switch the speakers, there's a correct way to do that, right? And the correct way to do that is the speaker speaking says generally that he is done. He wants the other speaker to take the podium. And then he takes a step back, walks to the place that he's sitting. And once he has taken the seat, the other person stands up and comes to the podium. Remember, the time taken during this transition is not calculated in your total time in any of the national moot courts. So in that context, you do not have to be in too much hurry when this transition from one speaker to other speaker is happening. So you can take this time where one person is taking a step back, coming back to the podium, coming back to the seating place, and the other person then stands up and then goes to the podium, right? Now, the last thing that I want to talk about here is the last part of your submission. The last part of your submission is your prayer. So whenever you're reading the prayer, right, and underline, highlight the term reading the prayer, right, all the members of the team should be standing. It's just the custom of moot courts. So all the members of that particular team, not the opponent team, right, of the team that is submitting the arguments should be standing while the prayer is being read, right? So this is the general mannerisms that you follow in a court of law. Remember, there are few hidden rules, or rather say assumed rules, which are there, which is that you see, we have borrowed a lot of these customs from the British courts as they were there. And if you look at the language which is used, right, if you read, let's say, the language which any of the former what is the old lawyers used to write, even if you read normal letters, right, you'll see that they will sign off with pleased to be your loyal servant, right? Now we use yours sincerely, we use yours faithfully, right? Now somebody is using the language that your loyal servant. Does that mean that the person wants to be a servant to the person? No. It is merely what do you say, honorific sign off where you are trying to show to the other person that I value you, right? If you've read any of the so the letters, and this particular change has taken place during my lifetime, where there was a particular way in which we used to write applications at one point of time, and then it changed. So if you look at the earlier form in which we used to write applications, the language which was used, I beg to state that, right? Still, if you find people writing in the older forms of formal communication, right, they'll use the word beg. This word beg does not mean somebody is begging, right? It simply means that it is showing that respect to the person to whom the communication is being made. So this was the formal uh, structure of uh, making submissions to any person, right? Though it has more or less from the other forms of formal communication, it has started to disappear. But in legal communication, this level of being supplicant, being uh, what do you say, under the authority, having the sense of the authority is very much followed. So your body language should follow the same logic in that sense. That means you understand that you are there to get a relief from the bench. You're there to get a relief from the bench. Court has mostly a discretion as to allow you or not in that case. So in that case, you want to be as humble as possible to the court, to the bench. Generally, when there is any kind of what do you say, sense of what is a pride, arrogance, or sense of what do you say, you're trying to undermine the authority of the judge or of the bench through your body language, it is not well received. It is never well received. And there's something that needs to be practiced. That if you are coming across, some people have a very what do you say, innate body language. It is there in their normal persona that you will feel that certain people walk and you feel that that walk is aggressive, right? Some people you'll see that is um, they are speaking normally, but you'll feel that the way of talking is aggressive, right? So in terms of that, it is very important to practice humility in tone of voice and the body language. Take a feedback from somebody. If you are coming across as what do you say, non-supplicant, take advice from somebody that what's happening, why you are not coming across as the most humble pleader that you can. It's very important. And humility, learning humility for a law student is probably the most important thing. Legal profession requires humility. When you join legal profession, you'll realize that a humble person, a person who has humility, makes faster strides in their career as compared to somebody who may not be as humble, even if the other person is more intelligent and more skilled in the trade as well. Humility goes a long way. Now, so that covers the first part of what I wanted to talk about, which was your body language, your approach to the court, and your the way you behave in the court. The second part is more important. Second part is more important, and which is argumentation. First of all, understand everything that you write in a memorial, whether it is coming in the chapter of argument or not. whether it is coming in the chapter of argument or not, it is part of argumentation. It is what uh, you are submitting to the court, right? And therefore, the few important thing is using each part of your memorial and your therefore your oral submission to your advantage, right? Now, let's start with the very beginning, right? The first thing in a moot court is salutation. It's called salutation. The first thing that you say when you reach a podium is called salutation. Can somebody just tell me how salutation goes? If anybody is aware of that, that'll help me proceed faster. Anyone?
Sir, we generally ask counsel seek permission to approach the dais, and then we ask, sir, we would like to मैं हिंदी में बोल देता हूँ सर, मैं भी बोल रहा हूँ हाँ कि हम आपको एज ए सर या एज ए लॉर्डशिप बोलना चाहते हैं या उसके लिए पूछ लेते हैं एक बार के लिए.
ठीक है. And
then वो जैसा बोलते हैं वैसे कंटिन्यूस.
उसके बाद what is the first thing that you say?
My lordship, yeah, sir.
So first thing that you say is, may it pleases the court, may it pleases your lordships, may it pleases your ladyship, as the case may be. So if there is one lady judge sitting there, you say, may it pleases the ladyship. If there is one single judge sitting there, you ask, may it pleases your lordship. And if there is a division bench or there are more people sitting there, may it pleases the court, right? In that context, one thing remember that sometimes, okay, it is again something that you ask, that the counsel seeks permission to call the court cumulatively as the court, or call the court, address the bench as your lordships. But remember, if there's a single lady judge sitting there and then you say the counsel seeks permission to call the court as your lordships, trust me, you are losing marks there. So there's one lady judge, right? She's ladyship. You don't have to ask for permission. So it is not a script through which you go always. So you have to keep your mind open. There's a one lady judge sitting there. You don't have to ask permission. You can call her your ladyship. Even if you have asked permission, if it's a division bench, to call cumulatively as your lordships, if you're answering to a lady judge, even if you have already earlier asked permission to call the bench as the court, when you're answering to a lady judge, let's say, you always answer your ladyship, right? So ensure that these small things are taken care of. Again, in that case, one thing which is very important is understanding of the forum in which you are arguing, right? This is one mistake that a lot of people do. They don't research about it, right? So I remember there was international moot that I was judging, and it was the forum was supposed to be ICJ, International Court of Justice. And then the person says that, may it pleases your lordships, right? My brother judge in that particular case objected to that. You cannot use that. Then the person corrects himself, says that, may it pleases your honor. So you still cannot call us that, right? So okay, I got a question on that as well, so I'm covering that. So every forum has a way in which you address the court. Your honor is generally used for lower courts, right, up till your district court, excluding your tribunals, right? In tribunals, generally you say Honorable Chairman and the members of the tribunal, right? Um, Sometimes in some of the tribunals where there's a judicial member, Your Honor works to some extent. You do not use the word Your Lordship in lower courts, right? In your constitutional courts, that means your High Court and Supreme Court, you use the word Your Lordship or My Lords, right? So when you're using the word Your Lordship and My Lords, remember, again, there's a common mistake a lot of people do without realizing it. And even this is something that I've seen multiple times when people argue My Lordship, right? My Lordship means that, or it implies that you are the Lord, which is not the case, right? So it is either Your Lordship or My Lord. It is never My Lordship. Remember this. There's a mistake that I've seen umpteen number of times, many times, right? For international courts, you'll have to check which court is there. General trend is Your Excellency, right? Your Excellencies. Or sometimes Honorable Chairman, if it's a, let's say, tribunal, international tribunal of that sort, then Honorable Chairman of the tribunal and the members, that works. So you'll have to find out what is the correct way of salutation, and that you'll have to do the research before. These are small things that people don't realize makes a huge difference, right? So you say, let's say, may it pleases the court, may it pleases your lordships, whatever. Then you introduce yourself. In a moot court, you do not introduce yourself by name. In most of the moot courts that is organized, you are given a team code, right? Therefore, you do not identify with a name or a name of a college if it's a national moot court. You do not reveal name of the college. It is prohibited in all national moot court competitions, right? Okay, there's a question that what's the difference between Your Honor and My Lord? Why My Lord can't be used in lower court judges? So it's just a matter of custom. It's as simple as that. The answer is as simple as that. There's just a matter of custom. This is how it has always been. This is how it is in courts of law even. So even if you're going for a courts of law, many of the modern judges use the word sir. They accept or rather promote use of word sir even. But again, as I said, that moot court, in the moot courts, the what do you say, stakes are a little higher. The scrutiny is a little higher. So we do not use the word sir, because even now most of the judges like that honorific titles of Your Honor or My Lord or Your Lordship, right? Both of them have different origins. There is no hard and fast rule of why this is said in that fashion, but this is the part of customs. That's all that I can say about that. Okay. Okay, Vaibhav, you want to say something?
यस सर सर वो बीसीआई रूल्स के अंदर ये लिखा हुआ है कि सुप्रीम कोर्ट और हाई कोर्ट के लिए योर ऑनर एंड द लोअर कोर्ट्स के लिए सर.
Which
तो सर ये मतलब सर पार्ट 6 चैप्टर सी ऑफ बीसीआई रूल्स.
Let me check once from but what I remember, right? And I'm very sure of is in the Supreme Court and the High Courts, the term Your Lordship is exclusively used. Right.
Yes, there were यहाँ पे एक explanation भी है वो my lord और lordship को relic of colonial past बता के उनका use को मना कर रही है.
बिल्कुल बिल्कुल. That is what I'm saying. That is what I'm saying. There are a lot of judges. There are a lot of judges who accept the use of the word sir, even not even Your Honor, not even my lord or Your Lordship. Right. They are happy with the word sir. Right. Now, but as I told you that when we are training you to do something, right? We are training you for the best case and the worst case scenario, right? Not a particular situation where some judge might see. A judge might be okay with the word sir, that you are calling them sir. It's fine. There are other judges which might not be okay with that, right? And when you're looking at other way around, when you're calling somebody, let's say your lordship or my lord, they may tell you to call them sir instead, but nobody is going to be mad at you for calling them your lordship, right? They might correct you, right? So this is why I'm saying we are preparing you for the best and the worst case scenario. That's the idea. There have been a lot of development in this field. There are a lot of courts, a lot of judges who are happy being called uh, sir, right? In US, if you look at the courts, the judges are sometimes called by the name or their surname. So uh, they'll just say, just Faulkner, you, I would like to submit to you that, right? So what you're doing is you're using the name rather than not even a sir, right? Sir is even a very Indian thing, right? And yeah, you're right that there are resolutions, there are bar councils which are getting involved in that. But as the custom goes, as the practice still remains, right? The general prior practice, exceptions will be there, right? Uh, you can tell me hundreds of exceptions, and I completely agree with you when you say it's the relic of colonial past, right? We should get rid of it, but till now we have not done that, right? And now, sitting at university is not my job to determine judicial conduct. We can suggest, obviously, we can suggest, we cannot determine that, right? A lot of things are changing right now. The Lady of Justice, the idol of the Lady of Justice was changed, if you have seen, right? The blindfold was removed, right? And the sword was removed. So there are a lot of things which are changing, but call it relics of the ancient past, still remains part of the practice, right? And the point of moot courts is to prepare you for that. You may find exceptions while arguing, but as it remains, it's still the most accepted term across the country, right? So 90 out of 100 judges you'll find will still be attached to or be expecting you to use these salutations, right? I hope that makes things clear, right? Now, the next part is when you have done the salutation, the next thing that you say is generally you ask for permission that if the court is well versed with the facts of the case, the counsel would like to move the issues, right? You generally say this because generally in moot courts, the judges who are sitting there would already been briefed about the case by the organizing committee with the issues involved with the relevant cases which are applicable, which is drafted in a document called Judges Memo. So they actually have a kind of a memorial where all the legal issues and the relevant cases that the draftsman of the moot problem have thought of or has referred to is already there with every judge. So therefore you say that, okay, if you know it, we'll skip it, right? So if the court is well versed with the facts of the case, the counsel would like to move the issues. Now comes the first strategy of argumentation. A lot of people make a mistake of reading the facts as being provided to you by the organizers. So you copy paste the fact sheet, and you copy paste the fact sheet, and while if the court says that I want you to read the facts, you read the facts as it is given, right? Understand that if first of all, there are a lot of things which doesn't need to be in the part of the fact sheet. The fact sheet represents what are admitted facts. That means the facts on which the arguments are going to take place. In that, there'll be a lot of universal facts or a hypothetical universal fact, right? Like country A is in the B ocean, it's an island country. So think about this. If you're standing in front of a Supreme Court, are you going to say that India is a democratic republic country situated on the north of Indian Ocean? You're not going to say that, right? So remember to redraft the uh, fact sheet with the facts which make up the issue or which are going to be argued for the purpose of the issue, right? It's very important. And then without eliminating any fact. Remember, this is crucial. Without eliminating any fact, you use the tonality of the language, you use the vocabulary of the sentence, you use the punctuations to represent somehow that the facts is somehow favoring your party. So if you're from the side of plaintiff, then it is somehow facts are leading to a place where plaintiff is has a legal high ground, right? Again, it's a very important thing that you do not change the facts. You do not change the facts. You do not erase any facts. You're not silent on any facts, right? If you take away any facts, then it is actually cheating. So if I am uh, mooting against a person and the person has not written a fact which is part of the fact sheet, I will object to that and I will bring it to the notice of the judge that the counsel for the opposite party has tried to manipulate the facts in their submissions, right? That, again, these are subtle rules that people are not aware of, which sometimes gives you an edge. So if the other party is trying to pull any what we call cheap tricks, you bring it to the notice of the judge immediately, right? Trust me, these are things that the winning teams do very well, right? Now, then the next part of a memorial, which is very important, extremely important, which people are not giving as much attention to, and I don't know why, is statement of jurisdiction. Now, when you're writing statement of jurisdiction, what you need to figure out is where is it written that you have the power to file the case? Which section is violated is not the jurisdiction. Jurisdiction is where it is written that the court can pass certain orders, the orders that you want. The court has the power to issue the orders that you want from your party. And in that context, your statement of jurisdiction and your relief as the prayer should be aligned. Remember this. So if, let's say, somebody has approached the Supreme Court of India under Article 32 of the Constitution, it is expected that the relief that you have asked for is one of the 5 writs. I hope all of you are aware of the writs. Okay, can somebody tell me which year students am I addressing right now? Or is it mix of all of them?
But actually, mix of all.
From the first year to the final year?
Yes.
All right, perfect. All right. So for the first year students, probably you'll learn about it a little later, that there are 5 different types of writs under Article 32 of the Constitution of India. But see, this is what it is. So if you are approaching any court, uh, think about the orders which is under the jurisdiction of that court, the orders that that particular court can pass, right? So if you are going to a civil court and you are asking for death penalty, right, then you have a problem, right? And remember the rule of lowest court of jurisdiction. Find out which should be the first court in which the case has to be filed, right? Which is the trial court of this, right? Um, do we mention only the number, or we also give the relevant provision? Okay, not just you give the number and you state the general practices, that you state the provision, but the evolving practice right now is you write an extra sentence there establishing that this is the first court that we could have come to, right? So this court, not just this court has jurisdiction, only this court has the jurisdiction, and this court are the first jurisdiction, right? So you add, uh, so this court has jurisdiction under, let's say, if you're going in SLP to the Supreme Court of India, and you're saying that this court has jurisdiction under Article 136 of the Constitution of India, which says this, and in absence of any certificate by the High Court involving any substantial question of law and involving major question of facts where the fundamental rights, or for that matter, which is of general public importance or something of that sort, this requires, or this is the only resort left for the petitioners. So you're adding that part in your jurisdiction where you are stating that there is no other court which you could have taken cognizance of this, right? Now, when you are making arguments, right, generally you do not read your memorial. If you're reading your memorial, that's a very bad sign. Generally, what you prepare is called a written arguments, right? You prepare a written arguments, and when you're preparing your written arguments, you cannot go beyond the scope of your written arguments, your memorial, but you can always expand on it, right? It is very important to understand, first of all, what is an argument. An argument is not a case law. An argument is not a section. Argument has two structures to it. There is an inductive argument, there is a deductive argument. And there are two types of argument that you make, right? A deductive argument is, this is the law. These are the facts. This law applies to the facts in this fashion. So you break down the law in its essentials to satisfy the criteria of that particular law, what all should be required. So you lay down that, and then you satisfy those elements of the law in the problem, in the facts, and then you write the claim. You're saying that hence this is what it is, right? This is the law, these are the facts, this is how the law applies to the fact, hence this is why this law is applicable. This is a deductive way of deriving argument, and there is an inductive way. In inductive way, you write first of all your claim. It is humbly prayed before this, or it is humbly submitted before this honorable court, that section, this let's say I'm taking a old section 66A of IT Act is unconstitutional. To prove the unconstitutionality of section 66A, the council will rely on these grounds, right, of unconstitutionality, right? And then you lay down, okay, what are the grounds of unconstitutionality? Let's say it is violative of Article 14, it is article violative of Article 19, it is article violative of Article 21, right? And then you lay down each one of them separately. Article 14, these are the ingredients. This is why it is violative. Hence, my argument. So you start with a claim. Generally, I like the inductive method better, right? It's a personal choice. There's nothing wrong in either of them. It's a personal choice about what is the kind of argument you want to make. But it becomes easier for a judge to follow when you state in the very first sentence what you want to prove to the court. And then you lay down the structure as to how you are going to prove that to the court, right? And then you start working through your arguments. And when you're working through your arguments, again, you never leave any section or any case law hanging. So you do not start throwing case after case after case after case. You explain with each case as to how that particular case is applicable in the facts of the given matter, right? How you are going to apply the law to the facts, right? In fact, this is another lesson that I actually learned while working in a court in the very initial years. What happened was I was given a draft to make a draft of a simple divorce petition. There was an application to be made, and then my senior entrusted me to make the application, and then I made the application in which I used about 30-35 case laws. My senior took the application, threw it in the dustbin. And this is what moot court had done to me. While doing moot courts, I became habituated of using more and more and more cases. Is it not what all of us do while going for moot courts? Understand it is much better to use fewer authorities, but ensure that the authorities that we are using are the most concrete authority there could be, right? So if there's a statutory provision, prove that, right? If there's a particular interpretation of a statute, then cite the statute, then cite the interpretation with the case law related to the facts. Important, related to the facts. Every single argument needs to have a conclusion. So you need to know how many arguments you are making. Argument one is this. This argument is being substantiated by this law. Second argument is this. This argument is being substantiated with this law, right? And this law means the statutory provision, any executive order, any judgment, right? And when you are again using judgment, be very clear about which part of the judgment you're using, right? Remember, if you're using authoritative judgment for what is called authoritative precedence, that means you are saying that this is the Supreme Court ruling and you must follow this. Remember, there are two ways in which we use judgments, right? One is called authoritative precedent, one is persuasive precedent, right? Authoritative precedent is if there is a law, you must follow this, right? And if you're using that argument that this judgment says this, therefore this court is bound and must order accordingly, in that case, you'll have to create an equivalence of what is called ratio decidendi. Remember, learning to read a case for argumentation is very important, and many people miss that. That they simply see that this line appears in the judgment, hence I am going to use this line, and I am going to make an argument out of it. It's problematic. It's very problematic, right? So you need to know that part of the judgment, which is called ratio discendi. And how do you identify ratio discendi? Look at the final order of the court. What are the final actionable points that the court has given, that these are the things that needs to be done, right? And when you find, and you'll find that in the last paragraph of any judgment. So right when you're citing any judgment, go to the last paragraph of the judgment. That is the operative portion of the judgment. And then go back and find out if it said that X is the action which needs to be done. Find out in the judgment where the court says that this is the reason why X needs to be done. What is the reason for action X being ordered by the court? That is your ratio discendi. And that is the only part of the judgment which creates authoritative precedence, right? So when you're looking at a judgment as somebody is sitting in a judge's chair in Moot court, they might ask you, why have you used this case here? How is this case applicable here? Why is this case relevant here? So when they ask you this, right, you should be aware that, see, this is the ratio discendi of this judgment, and this particular ratio is available in the facts, admitted facts of this case as well. So whatever was being argued there is being argued here as well. And therefore, this authoritative precedence. Apart from that, all the other parts of the judgment, you can always cite, but you cannot really rely on them. That creates an argument, but not a very strong argument, right? So you need to know where you are creating your strong and weak arguments. You may say that the court has created this, court has observed in this case this, but that is not a binding precedent, right? So using the authority in the right manner, again, you'll have to check, and there's again something that a lot of people miss on, is when you're using a judgment, whether that judgment holds good today or not, right? It holds good today or not. That means if a judgment is overruled, it's reversed, and you're citing that judgment, then if the other party catches on to it, right, then you're doomed. You're doomed for good. So there's no coming back from that. So that is very important to find out, and this skill is something that is transferable even into real practice when you go. Every person who ever wants to litigate needs to learn how to check authority of a case law, right? So learn how to use authority of a case law, whether it is still applicable, whether it is creating the right precedence. That means whether the arbiter dicta, which you are thinking that it is there, it's actually there. The law that you want to prove is actually there. So that becomes very important in that context. So that is the structure of an argument. So case law is not an argument. Sections are not argument. How those law apply to the facts and the conclusion that you draw from that is an argument. So remember what argument you are making. So when you tell me that, okay, in Keshwananda Bharati versus Union of India, the Supreme Court of India said that the basic structure of the Constitution cannot be changed. In XYZ case, it was said that XYZ is part of the basic structure of the Constitution. All of that is right. But then at the end, you have to say, therefore, XYZ provision of the Constitution cannot be amended, being the basic structure of the Constitution. So I am making a claim there. That's an argument, right? So if you leave at the case law and the judgment, case law and the judgment, and if you don't tell me why you are using that case law or the judgment, then that absolutely does not make any argument, right? Okay. The last part that I want to Okay, somebody has asked a question. If Manupatra is not available, then yes, you can check. See, Manupatra is one tool. I'll tell you something. When um I started doing moot courts, Manupatra was a novice. It was no good than um, what today is India Kanun, probably. Right. So it was merely a search engine. There was nothing more than that. Right. Now it has all the tools of checking. Even then, generally, when still I'm trying to check authority of a particular case, I like to go manually. I like to go to the library, find out the relevant reporters, and search for reference of that particular case. Right. Now, I cannot expect you at this age, that means in 2024, to do something that I was doing in probably 15 years ago. I cannot expect you to do that. But one of the ways you can do is, if a particular case is decided, right, then use the name of the case in Google. A simple understanding. Use the name of the case in Google, and for good measures, put it in inverted commas. When you put something in inverted commas, Google tracks the exact phrase. Right? It takes the entire phrase as one word. You can think about that in that way, and only it will show places which has the exact word. And then uh, in the search tools of Google, there is a year counter. Right? You can set, you want results from which particular year to which particular year. Right. So I'll go to Google, I'll set the time in last 1 year. Right. I'll write the name of the case, is in inverted comma, click on the search button, and then find in last 1 year. Generally, I'll be able to find something on there. So whatever I find in last 1 year, that means that case has been argued, that case has been discussed in any judgment. And when I open that judgment and find out when the case was being discussed, is it being taken as a precedent or not? Right? So I can read the most recent judgment which refers to an older judgment to find out whether that older judgment still has authority or not. Right? If I don't find that judgment in last 1 year, I'll try for last 2 years. Then I'll try for last 3 years. Right? I am going from in the reverse from today's date, because I want the most latest judgment which has discussed that particular judgment. If, let's say, I open for last 1 year and I get, let's say, 5,000 results, in that case, I will shorten it. I'll say that last 1 month, then last 2 months. So I'm trying to find the most latest judgment in which that particular judgment appears. And that will give me enough information about whether that judgment still holds authority or not. I hope that answers the question. Right? Okay. So Manupatra is just a tool. You can do all kinds of things without these tools. Okay. The next thing that I want to talk to you about, and since I think I'm running out of time as well, right, I will quickly talk about one very important point while making submissions. I said that you have to be polite, right? You have to be the supplicant. For showing your supplication, for showing that you are surrendering to the authority of the court, the vocabulary that you use is very important. And the very beginning, I said that I'll discuss that towards the end. So I started by saying that in the CGI's court, some judge was using the word, some lawyer was using the word yeah, yeah. If not yeah, then what? You don't even say yes. Right? The word generally we use is indeed. Exactly. And if court is saying something that shows a negative action. Negative action as in you have not done something. So court says that, so that means you have not done this, right? Then you say, indeed not your lordship. Indeed your lordship, indeed not your lordship. Both of them are used to agree to the court in a positive and a negative sense. Agree to the court. You do not disagree to the court. Remember this. Come what may, you do not disagree to the court. Right? Then what do you do? If court says something which goes against your argument, if you do not agree, if you cannot disagree, then you surrender. You don't want to surrender. You use the power of language. And then you say that, your lordship, the council would like to approach this subject from a different perspective, if your lordships may allow. Right? The courts might sometimes become angry at it. As I said, do you want to say that what I am saying is wrong? I would say, indeed not, your lordship. The council has absolutely no motive of stating anything of that sort. The council just wanted to add a perspective for better clarity on the issue. So essentially, you never disagree, even if the court is saying something wrong. Right? There's a politer way to approach that. You do not say that you're wrong. They take it. You never know that who takes an offense of it. Right? There's an aggressive way of approaching this. Right? Which is used very strategically. Right? Not always. You cannot say that, your lordship, I want to ask you this question. You never ask a question to the court. But you have to ask a question to the court. You want to know why they said something that they said. And then you say, your lordship, I ask myself this question, that why it cannot be, let's say something is, court says that this cannot be part of basic structure of the constitution, let's say. I say, the council asks himself this question, why this cannot be this. So, but again, this is an aggressive way of approaching it. Use it very strategically and tactfully. Right? There are both pros and cons of using this. But if anything, if you want to ask a question to the court, this is the way to go. You never say this. And that brings me to another thing, and this is something that again I learned while I was sitting in court of Honorable Justice Gyansudha Mishra. She was sitting in, before she became the Supreme Court judge, she was sitting in a court as a judge of Jharkhand High Court, where there was a junior lawyer which came to a court and started saying that, please come to this page, please come to that page, please read this page, please read this or that page, please read this annexure, please read that annexure. Now the gracious lady as she is, she cut him some slack for a couple of these times, but then ultimately even she had to discipline the person and say that, you are not going to order me to read this or go to that page or read that annexure. So you never say that, your lordship, please come to this page, go to this page, come to this page. Both are unacceptable in a moot court. If I may draw your attention to submissions made in page 12 of the memorial, if I may draw your attention to, right, or if I may read, you're not saying that you read, you're saying if I may read page 12, submissions under page 12 of the memorial, and then you go on. So remember, ultimately, that you cannot direct the court to do anything. You cannot tell the court to do anything. Right? You will always say that I am doing this. You please consider this. And finally, the last thing that I want to say before I open it for questions is there are two words which we use most often in any submissions. So if I am saying 1,000 words in my submission representing this case, there is going to be at least 50 to 100 words. These are two words used frequently, as frequently as possible, that is much obliged, your lordship. Court asks you any question, you don't start answering. You thank the court for asking the question. If they grant you time, to what do you say? Let's say extra time for a minute or 2 minutes, or if they agree to your point, they disagree to the point. So whenever the court says anything, and after the court you are starting to say, you are going to start with much obliged, your lordship. Even if the court has scolded you, and then you have to start your submissions again, you start with much obliged, your lordship. Remember, anytime the court says anything, you ask permission from the court, that the counsel seeks permission to, if the court is well versed with the facts of the case, the counsel seeks permission to move the first issue. Court says proceed. You do not start, it is submitted before the court. You say, much obliged, your lordship. Right? And then you start whatever you have to say. So these two words, much obliged, your lordship, is lifesaver in a moot court. That shows what it is. So that's in brief what I could highlight in 1.5 hours that I had. There's much more intricacies into argumentation. Somebody, I think, had asked me, from where can you read this? There is a book called, I'm not able to recollect the name of the author. The name of the book is Art of Argumentation. So that is one very good book to start with. That is Art of Argumentation, where you learn how you make arguments. Next thing is probably, a lot of civil procedures are the procedures you learn much later in your curriculum. And therefore, what happens that when you're going for moot court, let's say in first year, you're not aware of the procedures involved. In that case, there's again a very small book which is kind of a summarized form of civil procedure. Right. So the name of the book is, it's written by Sardin Shah Mullah, one of the greatest lawyers India has ever produced. The name of the book is The Art of Indian Practice. Right. A Key to Indian Practice, rather. A Key to Indian Practice by Sardin Shah Mullah. It's a very old book, but it is revised quite often. So these are few books that you can begin with. There are other resources available by different authors on Handbook of Moot Courts. Dr. B.M. Gandhi's book on moot courts is also a very good book on moot courts. Right. But I believe that the first book any mooter should read is The Art of Argumentation. Okay, so that's all that I had to speak. If there are any, okay, one question is, does moot court have dress code? Very strict. Moot courts are very strict in terms of what do you say, dress code. So in all the national moot court competitions, it's a black blazer, black tie, white shirt, black pant, black shoes, well polished, very clean. Remember, your appearance has marks. And I'll tell you that it's a psychological fact which has, there are a lot of research which is done in this area. right? And there's a reason any interviewer, if you're going for any interview as well, there's something that is going to be told to you, right? That is, you should look your best. You look more attractive, judges are going to listen to you more, right? If you're giving an interview, the interviewer is likely to listen to you more, right? And there's not something that I am picking out of thin air. This is actually a psychological fact which has been like published journal, right? And for women, there are two ways. One is again white shirt, black pant, black coat, right? Another one is black blazer and your white what is called salwar kameez in Indian way, or salwar kameez with a black dupatta. That's so they're uh, organizers have their own discretion, so it's code of law. Uh, I don't think there's any college which prohibits wearing hijab. It has to be black in color, though. It cannot be any other color. So again, it depends on the organizers to some extent, right? In courts, from what I remember, a complete. So I'm not aware of different types of attires. So I'm given to understand there's a hijab, there's naqab, there is other attires in the same category. So I believe, right? I'm not completely sure. You'll have to check the High Court rules in that regard, right? I believe your so the hijab which covers from head to toe, probably that is not advocate's dress, under the advocate's dress. But I believe the face cover which exists, that is, I believe, allowed. Right. So
Is there any questions you may ask to Mr. Shashank Kumar?
yes, you can unmute yourself and ask me question as well. And if you want to ask in Hindi, I can perfectly understand Hindi as well.
Good afternoon, sir.
Yes, Anksha, tell me.
My name is Akansha Sharma.
Yes.
And I wanted to ask a question regarding if we are presenting our matter in the moot court or in the like rear honorary court. Do we have to how do we ask if the bench is a lady judge? So how do we ask that? Like how to ask for that if we may pronounce them as a ladyship?
So if it is just a lady judge, right? If it's just a lady judge, you don't ask. You don't ask at all. You assume that you're going to call them your ladyship, right? So you're going to use the word your ladyship.
Am I audible?
Yes, 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 you are. So I hope I'm audible to you.
Yes, sir.
All right. So I was saying that if it's just one judge, one lady judge, you simply say your ladyship. You don't ask. If, let's say, there is a lady judge and a male judge sitting there, right? Then in that case, you ask, you say that the council seeks permission to call the bench cumulatively as the court, or call the bench cumulatively as your lordships, right? It's better to say cumulatively as the court, because when you ask them to be called as your lordships, sometimes the judges are in a mood of taking some fun out of the thing, and then they might ask you, why did you ask your lordships? Why not your ladyships? Right. So to avoid, because see, they'll have fun on your time and then your time will see. It's very important to take care of the time part of it as well. So when you are making an argument, one thing is again very important is every moot court, every good moot court problem will have strong points from both sides and weak points from both sides. If both of that is not there, moot problem is not good. So you should know which is your strong argument, which is your weak argument. And in terms of that, you'll have to ensure that you are giving more time to the strong argument than the weak argument. Right? So division of time is very important. Can we say that we do not agree with our opponent in argument? You can always say that. Right? You can always say that. Again, there are different levels of how you say that, right? So a very what do you say, simple way of saying that the argument presented by the opposing counsel may be misleading, right? Or you can say that the arguments offered by the opposing counsel may be rejected on the grounds this, right? Now there are different styles of pleading, you know. Sometimes taking a more aggressive approach. Again, I'm telling you what are the aggressive approaches of argumentation, but I'm again giving you a warning that if you do not have the right context before and after it, these are not taken in good light. So the aggressive way of saying the same thing is ridiculing the opponent's argument, right? So you always you can say that I find the argument of my opposing counsel amusing. So you're ridiculing the other person's article. You are calling it amusing, right? If you're going more aggressive, then you can always say that the counsel would wish to point out that the submissions made by the opposing counsel is a deliberate attempt to mislead the court, right? When you're saying, but if the argument of the opposing counsel is that weak, where it is very weak, you can always say that the counsel would like to submit that the submissions made by the opposing counsel on this point is very misleading, and they're trying to misdirect the attention of the court. Okay, Weber, your question. So that is how you disagree with your opponent. You can always disagree, right? In fact, after the pleading, after the arguments, you save some part of pleadings for what is called rebuttals. And in rebuttals, that is all you do. You disagree with your client. That is the part of it. Okay, another question that I see here is, should you use my client or I? You always use I. You always, when you are arguing in the court, you are the client. You are him, right? And that is something that is followed in normal courts as well, right? So even when you are arguing in the court might ask you that, okay, when did you get divorced? And you cannot say that, sir, I'm still married. He's not telling you that you got divorced, your client got divorced, but he will address you. So even the judge will address you as your client, and you will answer him back as the client. This is what it is. Are there different levels of moot courts? Yes, there are different levels of moot courts. But again, I'm telling you something. Bar Council of India recently came out with a circular and said that you cannot use the word national or things like this in a lot of moot court competitions or other competitions as well. So in terms of without seeking permission from the government. So now these terms may not be used as it is. right? So, after giving this disclaimer, there are state level. So every college generally has an intramural moot court competition, which is open to the students of that college or that university itself, that institution itself. Then you have a state level moot court competition, where the invitation goes to the all the colleges in that state. Then you have a national moot court competition or national level moot court competition, where participants from all over the country participate, right? And then you have international moot court competition. Now, when you talk about international moot court competition, again, we have to be very careful. There are certain international moot court competition which call themselves international moot court competition because the problem is based on international law. But then there are real international moot court competitions which are organized by international bodies, and they are participation from all around the world. So when you talk about the international moot court competition, your JSEPs, your so Philip C. JSEP is one moot court competition which is at the very top of the world, right? You'll find students from Harvard, Yale, National University of Singapore, all the top institutions in the world participating there. And a lot of students from India participate there as well. So you have to clear the national round, then the international round happens in Chicago. Then you have ICC, International Criminal Court moot. Then you have Stetson, which is an environmental law moot. These are recognized international moot court competition. There are a few more. There's Oxford IPR moot court competition, which is a very important one from Oxford University. Then at the national level, probably the most prestigious is called BCI Moot Court Competition, Bar Council of India Moot. Apart from the Bar Council of India Moot, different university of repute have their own moot court competition. So universities have their own moot court competitions. Some of them have a larger legacy, which have been happening for years together. So generally, they have more recognition because of their continuance for years together. So these are different levels of moot court competitions.
Thank you so much, sir, for your invaluable insights on courtroom etiquette and argumentation skills. We appreciate all the participants for your active engagement today. Now, I kindly request everyone to switch on their cameras to capture this moment. Thank you, everyone. Now, I would like to invite Ms. Pragya Sharma, ma'am, member of the organizing committee and assistant professor at KSLW, to deliver a vote of thanks.
Good afternoon, everyone. I feel really honored and privileged to get this opportunity to propose the vote of thanks for this extremely informative session. Learning of argumentation skills and courtroom etiquette is the core and the basic aspect of mooting, and no doubt it has been dealt with thoroughly in this session. Now, I, on the behalf of Kanuria School of Law for Women, convey deep regards and hearty thanks to our esteemed guest, Mr. Shashank Kumar. Thank you so much for accepting our invitation and enlightening the participants with your knowledge. Sir has guided extensively regarding the appropriate and the required argumentation skills that I'm sure would be very helpful for all the participants. Thank you so much, sir. Now, my special thanks to Principal Ma'am, Dr. Vartika Arora, for her constant guidance and immense help for shaping this session. I'm very much thankful to Dr. Disha Bangarwa, co-convener, Ms. Roshan Ali, organizing secretary, and our very own colleagues, my very own colleagues, that is the faculty members of KSLW, for their help and motivation. I would also like to extend my thanks to Ms. Reni Tawar for moderating this session. I am very much thankful to the non-teaching staff who always stood by us and helped us when we needed them. I would like to extend my deepest thanks to all the participants for joining this session and making it a successful one. Thank you so much, everyone. Thank you once again. Have a great day ahead.
Thank you, ma'am. Before ending the session, a reminder for all of the participants to fill out the feedback form in the order to receive a participation certificate for the workshop. Thank you all for joining us. Hope to see you in the next session tomorrow. Thank you.